The dining room at my parents' house seats 8. That evening there were 5 of us: my adoptive mother, Constance; my adoptive father, Gerald; my older brother by adoption, Philip; his wife, Soren; and me. The table was set the way it is always set in that house: linen napkins, the good china, candles that Constance lights regardless of occasion because she believes presentation is a form of character. I had driven 3 hours from Cincinnati to be there. I had chosen the evening deliberately. A Sunday. No major holidays, no anniversaries, no events that would give anyone an excuse to redirect the conversation. Just dinner. Just the 5 of us. Just a question I had been preparing to ask for 7 months. I waited until the main course was cleared. Until the wine had been refilled. Until the particular settling that happens at a table when people have eaten and the defensive posture of arrival has relaxed. Then I said, "I'd like to talk about my adoption. Where I came from. My biological family." The table did not freeze immediately. It hesitated, a half-second of collective recalibration, and then Constance set down her wine glass with the precision of a woman who has been waiting for this moment and has a prepared response. She looked at me across the candles with an expression I had seen my entire life but had never been able to name correctly until I was old enough to understand what it actually was. Not love. Control, wearing love's clothing. Sophia. Her voice was measured. "We've discussed this." "We haven't, actually," I said. "Not honestly. Your birth parents gave you up. There is nothing to discuss. I'd like to know more about them. Their names. Their history. Whether there are medical." "You should be grateful," she said, "that we took you in." The table went very still. "Without us, you would have nothing. No education, no opportunities, no family. Nothing. And I find it deeply hurtful that after everything we have given you, you sit at this table and treat your history with us as insufficient." Philip looked at his plate. Gerald cleared his throat and reached for his wine. Soren looked at the centerpiece with the focused attention of someone who has learned, through marriage, when to become invisible. I looked at my mother for a long moment. Then I said, very quietly, "Then why is there $1.4 million in a trust fund under my name, that you never told me about?" The candles continued to burn. No one said anything. And in the silence that followed, in the 4 seconds before Constance's expression shifted from control to something I had never seen on her face before, I understood that the conversation I had been preparing for had just become a different conversation entirely. My name is Sophia Renard Cole. I am 32 years old. I am a licensed archivist and record specialist at the Cincinnati Museum Center, which means, professionally, that I am a person trained to find things that were meant to stay hidden. I was adopted at 4 months of age by Constance and Gerald Cole of Columbus, Ohio. I was raised in a 5-bedroom house in the Bexley neighborhood, educated at private schools, sent to Ohio State on what I was told was a college fund my parents had saved. I was, by every visible measure, a fortunate child. I was also, for my entire life, forbidden from asking certain questions. Not explicitly forbidden. Constance does not operate explicitly. She operates through temperature, through the way a room cools when a subject is raised, through the way conversations are redirected with such practiced fluency that you find yourself, 10 minutes later, discussing something else entirely and uncertain how you got there. The subject of my biological family was a cold room. I learned, young, not to enter it. What changed everything was a box. In February of last year, my aunt, Gerald's sister, Patricia, who lives in Dayton and who has always occupied the family role of the person Constance finds mildly irritating, called me on a Wednesday afternoon and said, "Sophia, there are some things in your grandfather's storage unit that I think belong to you. Can you come to Dayton?" My grandfather, Gerald's father, Theodore Cole, had died in November. His storage unit was being cleared. I drove to Dayton on a Saturday. Patricia met me at the unit. She handed me a banker's box with my name written on the side in handwriting I did not recognize. Inside, a sealed envelope, a photograph, and a single legal document, a trust agreement, dated March 3, 1993, bearing the names of two people I had never heard spoken aloud in my parents' house. Marguerite and Sylvain Renard. My biological parents. The trust had been established for the benefit of their infant daughter, Sophia Marie Renard. It had been funded at its creation with $400,000 in bonds and cash. The name trustee, responsible for management and distribution upon the beneficiary's 25th birthday, or upon the beneficiary's request, with documentation of majority, was Constance & Cole. I sat in a storage unit in Dayton, Ohio, in February, and read that document 3 times. Then I called an attorney. The trust had been created in 1993. I turned 25 in 2017. I was now 32. 7 years had passed since the designated distribution date, and no one had ever said a word. The attorney I retained was named David Farrow, of Farrow & Associates in Cincinnati, specializing in trust and estate law. He was 54, precise, and had the particular patience of someone who has spent decades in a profession where patience is the actual product. I provided him the trust document, the envelope, which contained a handwritten letter I will describe later, and everything I had been able to reconstruct in the 3 weeks between the Dayton storage unit and his office. What I had reconstructed, using the tools of my profession. Marguerite and Sylvain Renard had emigrated from Lyon, France, to Columbus, Ohio, in 1988. Sylvain held a patent in industrial process engineering that had generated substantial licensing income throughout the early 1990s. They had died in a car accident on December 14, 1992, 4 months before I was born, which meant my mother had been pregnant at the time of the accident and I had been delivered by emergency cesarean and placed immediately in the care of the state. I found the accident report. I found the probate record from the Franklin County Probate Court. I found the trust filing. I found something else. A secondary document, a trustee acceptance agreement, signed by Constance & Cole on April 7, 1993, in which she formally accepted fiduciary responsibility for the Renard Family Trust, account number 774109R, custodied at Meridian Private Bank. She had known since I was 4 months old. She had known my parents' names. She had known about the trust. She had known that the money left for me, money my biological parents had legally protected for their unborn child before they died, existed, had grown, and was mine. David Farrow requested the trust account records from Meridian Private Bank through a formal legal inquiry. What came back, 6 weeks later, confirmed what the compounding math had already suggested. The $400,000 principal, invested across 32 years in a conservatively managed portfolio, had grown to $1.4 million. $1.4 million. In my name. That I had never been told about. The trustee has a legal obligation to notify the beneficiary at the age of majority, or at minimum at the distribution trigger date, David said, in his office, on a Thursday afternoon. Your distribution trigger date was your 25th birthday. That was 7 years ago. What does that mean legally? It means your trustee is in breach of fiduciary duty. It means there may be additional claims depending on what, if anything, has been disbursed from the account during that period. He paused. Have there been disbursements? I looked at the account statement. There had been 3. 2018, $47,000. 2020, $63,000. 2022, $38,000. Total, $148,000. There was no documentation of purpose. No beneficiary authorization. No court approval. She took money from my trust, I said. David did not answer immediately. I want to be precise, he said. What I can tell you is that the account records show disbursements with no documented beneficiary authorization. What that means legally is a question for the full investigation. I nodded. I put the account statement in the folder. I drove home. And I began planning the Sunday dinner. She had the trust document. She had the account records. She had 7 years of undisclosed distributions totaling $148,000, drawn without her knowledge or authorization. And she hadn't said a word to anyone. She had done what she always does, she waited. She chose the table. She chose the moment. Stay with me. In the 2 months between my discovery and the Sunday dinner, I attended 3 family events. Easter. Philip's birthday. A cookout in late May that Constance had organized for Gerald's colleagues. I was present at all 3. I was warm. I asked questions about Gerald's retirement plans, about Philip's renovation project, about Soren's work. I brought wine. I helped clear the table. Constance, at each event, was her usual self, composed, gracious, subtly authoritative, the conductor of every room she entered. She watched me the way she has always watched me, with the particular attention of someone monitoring an investment. At Easter, she said, unprompted, while we were alone in the kitchen, "You seem settled lately, Sophia." Grounded. "I think Cincinnati has been good for you." "I've been doing a lot of reading," I said. "Good," she said. "Knowledge is grounding." I agreed with her. I helped dry the dishes. What I was reading, specifically, was Ohio trust law. Ohio Revised Code Chapter 5808, Governing Trustee Duties. Ohio Revised Code Section 5808.13, requiring trustees to provide account statements to beneficiaries upon reasonable request. Ohio Revised Code Section 5810.01, addressing trustee liability for breach of fiduciary duty. I was also reading the handwritten letter that had been in the banker's box from my grandfather's storage unit. I had saved it for last. It was written in French, in a woman's handwriting, on cream-colored stationery. My French is functional. I studied it for 6 years and have maintained it professionally for archival work involving French-language documents. I read it with a dictionary and 3 hours and a cup of tea that went cold. It was from my mother. My biological mother. Marguerite Renard. She had written it, based on the date, 3 weeks before the accident. She had written it, I believe, because she was a person who understood that certain things should be said on paper regardless of whether you believe you will need them. I will not reproduce it here in full. I will say only this: she knew she was leaving someone behind. She wrote to that person. She described, in the careful and loving language of a woman who was also clearly an engineer's wife and therefore precise, exactly what she had arranged, and why, and what she hoped it would become. "We cannot know the shape of your life," she wrote. "But we can make sure it has a foundation." I read that sentence 11 times. Then I put the letter in the folder and I called David Farrow and I told him I was ready. The legal preparation was complete. The trust records were subpoenaed. The breach documentation was assembled. All that remained was a Sunday dinner and a single question that would determine whether Constance would tell the truth, or give Sophia everything she needed to proceed. After I said it, "Then why is there $1.4 million in a trust fund under my name that you never told me about?" The room held its silence for what I counted as 6 full seconds. Philip looked up from his plate. Gerald set down his wine glass. Soren looked at Constance with the expression of a woman recalibrating everything she thought she understood about this family. Constance's face moved through 3 expressions in rapid succession: surprise, which she suppressed, calculation, which she briefly allowed, and then the one she settled on, the one I had been expecting: wounded dignity. "Where did you hear that?" she said. "From the trust document itself," I said. Dated March 3, 1993. Trustee signature, Constance and Cole. That document is, she stopped. It's what? It's complicated. There are things you don't understand about the circumstances. Then explain them to me, I said. I've been asking for explanations my entire life. Tonight I'd like one. Philip cleared his throat. Mom. What is she talking about? It's a private matter between your sister and. It stopped being private, I said, when you accepted fiduciary responsibility for money that belonged to me and did not tell me it existed. Gerald looked at Constance. Connie. The trust was established by her biological parents before they died, Constance said, clipping each word to its minimum size. I was named trustee through the adoption arrangements. I managed it appropriately. You managed it, I said. Including the $47,000 disbursement in 2018. The $63,000 in 2020. The $38,000 in 2022. The room went cold in a different way than before. Not the cold of discomfort. The cold of exposure. Those were management expenses, Constance said. Management expenses require documentation and beneficiary authorization under Ohio Revised Code Section 5808.13, I said. There is no documentation. There is no authorization. Because you never told me the account existed. You were not in a position. I was 25, I said. In 2017. That was the distribution trigger date written into the trust. I was a licensed professional. I was an adult. I was, by every legal measure, in exactly the position required. Philip looked at his mother with an expression I had not seen on his face before. He is not a demonstrative person, we are similar in that way, though I did not know until recently that our similarities were architectural rather than inherited. But what was on his face in that moment was something past discomfort. It was shame. Mom, he said. Did you know about this money? This whole time? Constance did not answer him. She looked at me. I raised you, she said. I gave you a home. A family. An education. I gave you 32 years. You did, I said. And I am not here to argue about what you gave me. I'm here because you took something from me that wasn't yours to take. My name. My history. My parents. The word sat on the table like something fragile and irreplaceable. And $148,000, I added, that my biological mother set aside so I would have a foundation. She used her mother's exact word back to her. Foundation. The same word Marguerite had written in French on cream-colored stationery. The same word Constance had spent 32 years standing on while Sophia didn't know it existed. Stay with me for what came next, because what Sophia had built was not just an argument. It was a legal structure. David Farrow filed the formal legal action in Franklin County Probate Court on the Monday following the Sunday dinner. The action named Constance and Cole as respondent in a proceeding for breach of fiduciary duty under Ohio Revised Code Section 5810.01, failure to provide required accountings under ORC Section 5808.13, and unauthorized disbursements from a trust account in the amount of $148,000. The filing also included a petition for full trust accountings covering the entire 32-year administration period, and a motion for immediate trustee removal and appointment of a successor trustee, a neutral corporate fiduciary, pending resolution. Constance retained an estate litigation attorney named Warren Cross. He was experienced. He filed a response within 10 days arguing that the disbursements were legitimate administrative expenses, that the trustee had exercised appropriate discretion, and that any delay in notification was a product of good faith judgment regarding the beneficiary's readiness. That argument collapsed in 3 places. First, the trust document itself contained no discretionary language authorizing the trustee to determine beneficiary notification readiness. The distribution trigger was explicit, age 25, or upon request with documentation of majority. No discretion was granted. None was available. Second, David Faro had subpoenaed the Meridian private bank records in full. The three disbursements, $47,000, $63,000, and $38,000, had been transferred to a personal checking account held in Constance's name. Not a trust administration account. Not a legal fee account. A personal checking account. There were no corresponding invoices. No management fee agreements. No court-authorized trustee compensation schedules. Third, and this was the piece that Warren Cross did not anticipate, because he had not yet seen the full scope of what David had assembled, there was a fourth disbursement. Not in the bank records David had received. In the supplemental records obtained through the probate court's full accounting order. October 2015, $22,000. Transferred to the same personal account. I had been 24 years old. I had been 1 year from the distribution trigger. Total unauthorized disbursements, $170,000. Warren Cross and Constance's legal team requested a settlement conference. David and I attended in December, 4 months after the Sunday dinner, in a conference room at the Franklin County Courthouse Annex, 12 floors above the street, with a mediator named Judge Patricia Hollins, who had 31 years of probate experience and the efficient stillness of someone who has seen every version of this story. Constance was present. This was, I later understood, a strategic error on her attorney's part. Some clients should not be in the room for certain conversations. When the full accounting was read, when the $170,000 figure was stated aloud, with its supporting documentation, in the presence of a retired judge, Constance looked at me across the conference table with an expression that I had never seen on her face in 32 years. Not control. Not wounded dignity. Something older and smaller than either. I managed that trust for 32 years, she said. To me, not to the mediator. Through your college. Through every difficult period. I managed it. I know, I said. I deserve compensation for that. You did, I said. The trust provides for trustee compensation. With documentation and court approval. None of which occurred. Silence. You could have asked me, I said. Any time after 2017. You could have told me it existed. You could have said, Sophia, there is a trust. There is money. Here is what it cost me to manage it. Let's make this right. And what would you have said? She asked. I looked at her for a long moment. I would have said yes, I told her. Because despite everything, you are my mother. And I understand what 32 years of work costs. The mediator looked at both of us. I think, she said quietly, we are close to a resolution. The settlement was reached in January. The terms, the $170,000 in unauthorized disbursements was to be restored to the trust within 90 days, sourced from the Coles marital estate. A formal trustee compensation of $42,000 was agreed upon, calculated retroactively against the trust's net value and 32 years of documented management, and deducted from the restoration amount, making the net payment to the trust $128,000. The trust was transferred to a successor corporate trustee, National Fiduciary Partners, a Columbus-based firm, effective immediately. Upon final settlement, the trust assets, $1.4 million, intact and undiminished, became mine to direct. I did not spend them impulsively. I am a person trained in the preservation of things, and I applied that training to what I had been given. I established a scholarship fund in the name of Marguerite and Sylvain Renard, administered through the Ohio Foundation for Arts and Sciences, supporting first-generation college students pursuing archival studies, library science, or French language programs. The initial endowment, $200,000. The remainder I invested through a fee-only financial advisor, in a diversified portfolio, with the instruction that I wanted it managed the way a person manages something they intend to pass on. I also did something I had not planned to do until I sat down to do it. I had Marguerite's letter translated professionally, by a translator I hired specifically because she specializes in literary French and understood that some documents are not merely informational, and I had it framed. It hangs in my apartment in Cincinnati, above the desk where I do most of my work, in a frame I chose because the wood matches the color of the stationery she wrote it on. Philip called me in February. He did not apologize for his mother, he could not do that, and I did not expect him to. But he called, and he asked how I was, and he asked if we could have dinner sometime. I said yes. I meant it. Constance and I have not spoken since the settlement conference. I do not know if we will. I leave that door neither open nor closed. I leave it where it is. I think about identity often. It is, in many ways, the professional subject of my life. Archives are memory made physical, the way that institutions and families and civilizations decide what they will remember and what they will allow to disappear. My adoptive mother made a decision about my identity before I was old enough to participate in it. She decided that the story of Marguerite and Sylvain Renard would disappear. That the trust would be a private management matter. That I would grow up knowing only the family I had been given, with no knowledge of the family I had come from, and therefore no basis for comparison, no framework for understanding what had been withheld, no language for the particular absence that I carried my entire childhood without being able to name. I do not know if she made that decision from fear. From resentment. From the particular human instinct to absorb what we manage until we begin to believe we own it. I have considered all three possibilities and I believe the truth is probably all of them at once, in proportions I will never know precisely. What I know is this. Marguerite Renard wrote a letter to a daughter she would never meet, on cream-colored stationery, in careful French, 3 weeks before she died. She described the trust. She described its purpose. She used the word foundation in French, which means the same thing but sounds like something you build a cathedral on. She said, "We cannot know the shape of your life. But we can make sure it has a foundation." She could not have known that the trustee would be the woman who raised me. She could not have known that the foundation would be hidden. She could not have known that her daughter would spend 32 years living one life while another was held in a bank account in her name, growing quietly in the dark. But she built it anyway. She built it because she was a person who understood that love, expressed with precision, can outlast the person who feels it. I think about that when I sit at the desk below her framed letter. I think about what it means to leave something for someone you have never seen, to arrange, with legal documents and compound interest and a handwritten letter, for a stranger who is also your child to have a foundation, even if you won't be there to watch them stand on it. I think about what I want to do with what I was given. And I think about what I want to say to anyone in this story who is still in the middle of it, who has felt the particular cold of being told that their origins are shameful, that their questions are ingratitude, that the people who provided for them are owed silence in perpetuity. They are not owed your silence. Your history belongs to you. The documents exist. The records exist. The letters exist. The trusts exist. The evidence of who you came from and what was left for you and what was withheld from you, all of it exists, somewhere, in a box in a storage unit, in a bank record, in a probate filing, in a banker's box with your name written in handwriting you've never seen before. You are allowed to go looking. You are allowed to open the box. You are allowed to sit in a storage unit in Dayton, Ohio, in February, and read a document that changes the shape of your entire life and then drive home and call an attorney and begin. Constance said, "Without us, you'd have nothing." She was wrong. Without Marguerite and Sylvain Renard, I might have had nothing. But they did not leave me nothing. They left me $400,000 in 1993 and a letter in French and 32 years of compound interest and a word. Foundation. I found it. It was mine the whole time. The scholarship fund received its first applications in March. 11 students. 7 states. Each one the first in their family to apply to college. The letter still hangs above the desk. Cream-colored stationery. French. Precise. Loving. We cannot know the shape of your life. But we can make sure it has a foundation. They built it. She found it. Now she stands on it. Go open the box. What's yours is still waiting. If this story found you at the right moment. If you have ever been told that your questions were ingratitude. If you have ever felt the particular weight of a history that was kept from you. Leave one word below. Foundation. That's all. And if someone in your life is still searching. Still sitting with the question they don't know how to ask. Send this to them today. Because the documents exist. The records exist. And what was left for you is still there. It has been waiting for you to come looking.